Hello, everyone. Welcome to Uncivil Law. Hope you're having a great day. We are here with our continuing coverage of the Vic Mignogna situation, where we are going to finally finish the appeal briefs. So far, we have covered on this channel. We covered the original complaints. We covered the response. We covered the TCPA. We covered the response. We covered the hearing. We covered Vic Mignogna's appeal brief. And now we're going to cover the last of the three appellee briefs. And yet the Vic people insist I still have no idea what I'm talking about, despite all this copious reading. But that's okay. I understand they love their guy and wish he would win. You know, whether or not he should win and whether or not he will win are different questions, guys. I'd just like to remind you, they are different questions. So we are going to try to finish this up today by doing Jamie Marchi's response brief and see if it answers any of the questions that were left unanswered by Funimation or Monica or Toy. So let's read their appeal brief. And I said this on the last stream, but I'll say it again. There is an issue, I understand, with some of these appeal briefs potentially being in excess of the word count that's allowed for by the rules. I don't know if they are. I'm not going to figure it out. And I don't particularly care that much because the most likely sanction, if they are, is the appeal court to strike them and to have them file a complying brief. So most likely sanction is strike the brief, file a different brief that's shorter. So, they'll file a different brief that's shorter that probably says the same substantive stuff. That's assuming it's an excess, which someone else can fight out about later. But, the most likely sanction is kind of a nothing burger, so I don't really care that much. Let's cover the Jamie Marchi response brief and see what it has to teach us in terms of this issue. All right, we got some stuff. We got some source of authorities. We got some more stuff. Does not believe oral argument would be necessary. If the court requests it, we want to participate. So they don't particularly want oral argument. They're happy to do it on the papers. Okay, that's fine. The statement of facts, the anime industry. Appellee Jamie Marchi, is a voice actor and writer who primarily works in anime. The term anime refers to hand-drawn and or computer animated originating from or associated with Japan. Appellant Vic Mignogna is one of the most ubiquitous voice actors in the anime genre, credited with over 356 productions on IMDb. He's also the voice of the title character of Dragon Ball Super Broly, the third highest grossing anime film of all time. Okay, good for you. That would also somewhat suggest public figure status, somewhat. Indeed, appellant can hardly walk into anime conviction without being immediately recognized. All right, fair enough. In approximately 2011, appellee Marchi worked as a voice actor for appellee Funimation on one occasion while at Funimation in Flower Mound, Texas. I don't know where Flower Mound is, but okay. Would it be helpful to spell out what a certain genre style is, like a court would know what anime is? I would not expect a court to know what anime is, no. So I do not begrudge them spelling it out. That seems like a reasonable thing to do. You have to factor in a lot of these, that the lot of judges in general are kind of older, not necessarily completely with it when it comes to culture, and there's a pretty good chance they don't know what anime is. So, spending a couple words describing what anime is probably a good idea. Yeah. On one occasion in Funimation's headquarters in Flower Mound, Texas, appellee Marchi was waiting in the lobby when appellant approached her. Considering that they knew each other was common greeting, and is a common greeting among creatives, appellee gave appellant a hug. Okay, apparently it's normal. What appellee Marchi did not and could not anticipate what happened next. Exciting. This is 2011? Going back 9 years? Okay. Commenting on appellee Marchi's hair, began running through his hand through the back of the hair until a palm found her skull. Splayed his fingers and moved his hand into the base of Pelly's skull, after which he clenched his hand in a fist, grabbing her hair at the roots, and jerked his fist, yanking the hair backwards. Having control of Marchi, appellant then pressed her lips to her ear and whispered something sexual. Appellee Marchi doesn't remember the specific words that appellant spewed. but she very much remembers he felt violated, out of control, and intimidated. I wonder in my own head a little bit as to whether or not some version of something resembling this happened. Like they do hug a lot, right? And Vic himself has said that he's a fairly like touchy feely kind of guy, and does that touchy feely kind of stuff in general, like hugs and very open. So like I wonder if he approached her and said got close enough to say something nice about her hair, and like whether some version of this happened, whether or not it's just all been like somewhat emphasized or like uh, built up in Marchi's mind, or maybe it did. I don't know what actually happened in the real world, and neither do you. But it's like, see, given that Vic himself has said he's a fairly physical guy when it comes to greetings, and very sort of gregarious in that way, I could see some version of this happening, and it's just an issue of perhaps interpretation. But it's a little odd, like if they knew each other very reasonably well, and like he had never done anything overtly before, like why one random day when they're just passing each other in the hall at Funimation Studios would he do something this aggressive? So it makes me wonder if something less aggressive happened and it's been sort of like build up after the fact. I don't know, just an idea. At all times during the assault, she did not want such contact as imposed. Shocked and stunned, Appellee Marchi never felt safe to Funimation again. Don't we know that they like hung out to each other and were fairly friendly to each other within public? I mean, considering Appellee was one of the most was one of the most ubiquitous voice actors, Appellee Marchi felt nobody would believe her if she told a story, let alone have a career survive. Like countless victims, she kept her story to her means herself, as retribution or further trauma. I mean, the whole thing strikes me as a little odd. I mean, it just strikes me as a little odd. I mean, I'm not saying it's impossible, but like you knew each other for a long time before this, right? And you knew each other for a long time after this, right? And nothing like this ever happened before this, and nothing like this ever happened after this. And you apparently didn't express any overt displeasure about it. So like he may not have known if he had done it that it was a problem. So what you're telling me is like one random day in 2011, for no apparent reason, as you're passing each other in the Funimation hallway, he just decided to like grab your bag, like, because what she's saying is like grabbed him like this, right? So by the base of her skull, so pulling it tight, right? That's what it's like. Could I see him? So, given what I know from him and what he said, could I see him hugging her? Sure. Could I see like even her touching her hair? Sure. Like as a friendly gesture, or smelling her hair, or saying it smells nice. Yes, I could. I could vaguely see all these things. But what you're telling me is that one random day in 2011, he reached up there, grabbed the hair, and pulled hard, and he never before did it before, and never did it again, or anything like it. On a random day, like why? Seems a little odd. I mean, okay. And like you yourself said, like you never told anyone, you presumably never told him, and never did anything like it ever again. Seems a little odd. Rumors about Appellant has swirled in anime for years before the 2011 counter. So much so that Appellant heard a rumor panel at a convention years ago to address various rumors plaguing him for much of his career. Okay. He wanted to have a rumor panel. Fine. Why do I care? Which is just as well. Like, why not just like ask me? It's basically ask me anything. Let's discuss stuff. Okay. At the beginning of 2019, Appellant's victim started speaking out about the pain Appellant had wrought. Seeing the hatred and shame Appellant's fall was attempted to hurl, Appellee Marchi could no longer stay silent. On February the 8th, Appellee Marchi bravely told her story. Bravery factor is questionable, but okay. Several years ago, I was in the lobby at my job when I was approached by a coworker. This guy gave me the creeps already. He almost always gave all the women the creeps. But I always feel like I had to be nice to him because of how revered he was in the industry. We hug a lot. On occasion, we give a kiss in the cheek. Okay, so you hug a lot, you give a kiss in the cheek. So, like, again, like if he kisses you on the cheek, he's close enough to smell your hair. So he might say your hair smells nice. Hell, I've said to people their hair smells nice without me getting anywhere close to them because I can smell it from like 4 feet away. So, it's like, all right. We hug a lot. Okay. I didn't say anything to him about it. I thought it's just fingers in my hair. I didn't think it was that big a deal. At that point, he splayed his fingers, put his hand on the base of my skull, and made a fist. Mm. When he did this, he grabbed my hair close to the root, effectively preventing me from moving my head. He jerked his fist, yanked my head backwards toward him, and whispered something in my ear. I don't remember what he said, but I do remember it being sexual. It's not normal. It's not just a hug or kiss. I did not like it. I have no memory of getting out his grasp, but I assume what the F were you doing as part of my technique. What's an appellant again? It's just appellant, appellee. Appellant is the person appealing. Appellee is the person being appealed against. So appellant in this situation is Vic. Appellee is everyone else. So yeah, appellant is the person appealing. Yeah. On March the 8th, appellant Marchi received from appellant a demand that she preserve all electronically stored information, other information related to claims and defenses. Ironically, appellant himself allegedly has a policy of immediately deleting his own electronically stored information. Has done so even after anticipating litigation. Also swapped off his own iPhone for a new one just as litigation trial was getting started. Well, incidentally, as a lawyer will tell you, if you have a routine data destructive practice, then it's not spoliation, right? If you are routinely, as a matter of course, whatever policy it is you have, like whatever your normal retention policy is, right? Like in the absence of a court order, the absence of like something, you can have pretty much any retention policy you want. Some people retain everything, some people retain nothing. You know? So like in the absence of something, if your normal policy is to delete everything, if that's your normal policy, then you can just continue deleting everything until like other side says stop, right? Because that's your normal data destruction policy, right? The whole thing like spoliation, the whole thing with spoliation is that you are deleting stuff in anticipation of litigation in a way that you wouldn't otherwise do, right? So you have a normal data destruction policy, but now you're just going to start shredding everything, as it were, right? Right, that shred party kind of thing, that's spoliation, right? But if shred party is your normal day-to-day activity, it's just your normal day-to-day activity. Spoliation is only where there's an abrogation in anticipation of litigation. So just a minor point. What's the Vic Mignogna case about? Vic, well, that's a tough summary, but let's give it a go. Vic Mignogna is a voice actor. He was accused of various things that we can all summarize in #MeToo. He was fired. Vic Mignogna is suing for defamation for things various people have said. He lost at trial. He is being ordered to pay something like $500,000 in damages, and now we're on appeal. Vic wouldn't have to show he'd done it before. Marchi's argument is he'd done it before. Marchi said he'd done it before. Appellant himself allegedly has a policy of immediately deleting his own policy, has done so ever, and done so even in anticipation. So according to Marchi, it's routine policy. So according to Marchi, it's routine normal policy. So okay, I'll take her word for it. Is it as a her or is it him? I honestly forgot. Sorry. Hold on. Is it Marchi or her or him? Hold on. Jamie. That doesn't help me. Jamie Emma doesn't help me. It's Marchi or her or him. I'll assume a her. I'll assume it's her. All right, where were we? Okay, has a policy deleting a new iPhone. Well, you'd have to know more about the time frame. Like, again, did a new iPhone just come out? Is this routine or is it not routine? Less than a month later, appellant sent Marchi correspondence asking her, okay, it wasn't her, thank you, to correct, clarify, or retract. Fair enough. Many statements complained of in the April 12th takedown letter refer neither to appellant nor contain any statement of fact, let alone rise to the level of actionable publication. Okay. While some of the site tweets admittedly contain strongly worded opinion commentary, none are false statements of fact, with knowledge of falsity or reckless disregard. Certainly none were made with malice, which is kind of the same thing you just said before, only with the intent to protect ourselves. The sole statement by Marchi that contains any statement of fact is that susceptible to truth or falsity was born by her need to tell the truth of what they did to her. All right. Appellant, that would be Vic, appellant filed his original petition on April 18th, 2019, making almost no reference to Marchi. Instead, appellant cites only Marchi's February 8th tweet, and a couple of other tweets, neither of which reference appellant nor any other statement of fact. When sworn under oath, appellant plainly admitted to assaulting appellant in exactly the same manner as appellee. So then let's see what appellant Vic has to say about the matter. And I'm like, oh my gosh, I love your hair. She's like, I know, I just got it. And walked around the counter. I was kind of standing there like flipping it. I'm like, oh my gosh, it's really beautiful. I love it. I put my hand in the bottom of it. I'm like, oh, this is great. That's not quite the same thing, but again, this was kind of like what I was like speculating to in the abstract. It's kind of like what I was speculating to in the abstract. And now here he is saying the same thing that I was saying like in the abstract, which I suppose is validating. It's nice when your speculation turns out to be grounded in a reality. It's always validating, right? So I was like, okay, he seems like a pretty touchy-feely guy. Here's something that probably happened. And now we get to read it. It's like, oh, okay, this is a thing that happened. So it's nice when your speculation's on point. Makes you feel validated. All right. The camera veered slightly to the right just before a gesture on the camera about the tight grasp. I don't know how much you can read into that grasp on that. Appellant then had the audacity to interpret how he thought appellee Marchi should have felt. It was not painful, it's not hurtful, it's not sexual, and happened at least 4 or 5 years he waited long for. I don't know if that's testifying to how you should feel as though his perception of it. Are you telling him how he should feel? Do you have the audacity to tell him how Vic should feel? Is that what you want to do? Vic says it's not painful. Is that telling you how you should feel or how he feels? It was not hurtful. Is that telling you how you should feel or how he feels? It's not sexual. Is that telling you how you should feel or how he should feel? And 4 or 5 years ago, it was a little longer than that. So that's just an objective statement of fact, right? Nevertheless, appellant admits individuals can perceive the same situation differently. Could have perceived her hair being pulled differently than appellant did. Yeah, no shit. People can perceive the same thing differently. Appellant gave the deposition on June the 19th, 2019, but never requested Marchi's deposition, even though he did depose Rial and Toy. We should probably go and read those depositions at some points, but they're probably like 300 pages or something, right? But it might be interesting to read their depositions. After appellee Marchi filed the motion to dismiss pursuant to the TCPA, appellant requested continuance hearing. Though this initially was opposed, parties ultimately agreed to reset hearing on mutual agreement to deadlines set out in the Rule 11 agreement and filed with the trial court. Do I know who Elizabeth Loftus is? I do not. No. Allegedly due to technical difficulties, they missed the deadline. Just after midnight, filed a response. It was probably technical difficulties. But yeah, you shouldn't really wait till the last minute. Attorneys do it all the time. They really do. It's bad policy though, man. You get burned once in a while. Other than by virtue of attaching the entity of the deposition transcript, appellant provided no evidence whatsoever referred to Marchi or claims against her. So basically saying you didn't bring claims against me. Okay. On the same day, Marchi replied to the brief was due. Only 3 days before the motion, filed a second amendment attaching 100 new pages of evidence and supplements. Appellant also withdrew affidavits attached to his response after appellees complained about the fraudulent nature. They keeps using that word fraudulent, which I think is a bit over-aggressive. It's not fraudulent, it was mistaken or at least legally defective. But fraudulent's a bit much. Appellant was trying to circumvent the Rule 11 agreement, TCPA, and the civil procedure unfair and impermissible effort to sneak evidence in, and they objected. Okay. That does seem vaguely like what happened. My understanding is that Beard himself has somewhat suggested that to be true. Again, I could be mistaken here, but my understanding is Ty Beard has basically argued that that was what he was trying to do. The Rule 11 agreement was carefully worded to not have this, and that he was using this rule that allowed things to be attached as a way to circumvent other things. Now, whether or not he could do that or not, it's a whole other set of can of worms. My understanding was that, yes, that was what he was trying to do. Yeah, Elizabeth Lufus is a psychologist who's done research basically showing witnesses are often wrong. Well, you don't have to tell me that, man. That I knew. I mean, I can go on Evan's book. Witnesses make mistakes all the time. Eyewitness testimony sucks. Eyewitness testimony kind of sucks. As a general rule. The appellees and their counsel all appeared for hearing respective to the motion. So compelling was the inability to present clear and specific prima facie case. The trial court dismissed all of them against them at the hearing. against Marchi. I guess that's true. Trial court further clarified its order that rightfully did not consider late filed evidence. The appellant failed to establish the stuff. That's fine. Summary arguments. As to all appellees, but especially Marchi, the law and facts of the case simply never fallen in favor of appellant or ill-conceived claims. The record before the court shows just what the trial court did. In absence of fact, clear and specific to the prima facie case. The appellant brief ignores Marchi nearly as much as appellant filing the trial court did. Which, is neither here nor there. Marchi is not, or may not be, the central fact of this thing. She is somewhat ancillary to the extent that she did anything, right? It seems like, Marchi is kind of off this to the side. It seems like Fundamation is kind of there only vicarious. So the only person we're really mad at really is Monica. That is our real target, right? And Toy to the extent that she assisted Monica. But that's fair, right? These are lesser important characters. Trial court must affirm. Fine. So we got some argument about the authorities. We need to do a plain error. Blah, blah, blah. Okay. Trial court dismiss is not reversible error. Appellant failed to establish clear and specific prima facie for every essential element. In order to meet, must prove forth specific evidence that Marchi published statement of fact that referred to appellant. It was defamatory. It was false. With regard to the statement, acted with malice, and the statement caused appellant injury, pecuniary injury. Appellant cites two specific examples from only 3 tweets by Marchi in his brief. First is an undated tweet in Marchi refers to appellant as a bad person without any context, which is opinion. A second is a tweet in which Marchi speaks generally about her feelings and opinion without naming appellant. Third is a tweet when Marchi describes what happened to her. Okay. For a statement to be actionable, B must expressly imply facts that are verifiable. Defamation only applies to facts. Appellant does not explain how or why a fact finder would conclude that either the undated tweet or the February 7th tweet contained assertions of fact. He misrepresents the nature and context of some of the statements in the February 8th tweet. The generic reference to the undated tweet to appellant being a bad person is not a statement of fact. That's true. It's not. An appellant even admitted in deposition doesn't carry any implication he's criminal. A bad person is just a statement of opinion. That's pretty open. Appellant doesn't even point to evidence establishing whether or not the concept that he is a bad person is objectively verifiable. It is not. Such a statement, though, reeks of subjectivity. As a matter of law, the undated tweet cannot say to contain a statement of fact, and it's not burned to prove otherwise. Well, if all you did was say that he's a bad person, like bad in what way? And like in any possible context, it's just a statement of opinion, right? Appellant expressly admits the February 7th tweet does not contain a statement of fact, and it doesn't reference appellant. As a matter of law, it cannot be said to contain a statement of fact. Though appellant quotes the March the 8th tweet as having stated that appellant has done this exact thing to a half dozen women that Marchi personally knows of, and he's a predator, that's a lot closer. These statements are not statements of fact when viewed in context. Really? Okay. Appellee Marchi stated she heard accounts of him doing the same thing to half a dozen other women she personally knew. Okay. Appellee Marchi does not state that he's done this exact thing to other women, only that she heard that he had, and therefore did not make a statement of fact about appellant. Well, there is a statement of fact that you heard about it about 6 other women. That's a statement of fact, right? Like that you heard it from 6 other women. That's still a statement of fact. That's not opinion. You heard of accounts doing this to a half dozen other women. That's a statement of fact. Did you hear about it or not? That's a statement of fact. And also, like, you're republishing. So, like, if you heard it and you're republishing it, you're usually liable for it. So, like, you're republishing the defamation implicitly. So, like, other people have said it to you, and now you're saying it. So I'd say that's republication personally. So I'd say it's a statement of fact, and it's republication. So I'd say that, yeah, you're liable for that as a statement of fact. Similarly, appellant misstates the nature of the word of the use predator, really. Appellee Marchi's tweet ends with a message: who's ever gone through a similar experience is cautionary tale, find themselves in a similar situation. Similar does not make reference to what appellant did to Marchi, nor is it a statement of fact. I don't really buy this reasoning. With regard to those exceptions, Marchi did not make a statement of fact referring to appellant. No, I don't buy that. I don't buy that. No, I'm not on board with any of this. No, I think this is a republication. I've heard I've heard this half dozen things from other women. You've heard it. That's a statement of fact, and you're also relaying it. So it's republication, and you're a predator. Predator is not just like bad guy. Predator is suggestive of fact. That is like bad guy. What the hell is that? Predator. We all understand what we're talking about, right? We got it. Especially when you're talking about half dozen other women and predator in the same sense. We're all on board. That's a statement of fact. A statement is a defamatory meaning only if its meaning is unambiguous in the mind of ordinary reader without any reference to any meaning attributed to by the plaintiff or defendant. In full context of everything, that's true. Appellant's only explanation regarding the defamatory nature of Marchi's tweet is that falsely accusing someone of crime or engaging in context is defamation per se. None of these tweets fall into either category. Predator, I think, is getting pretty close. A defamation per se, such as one appellant asserts, mandates the examining court to examine the entire publication. Appellants failed to provide the entire context of the statements. Without such context, there's no basis for the court to conclude they're defamatory per se. Due to the subjective nature, a appellee statement that appellee is a bad person can only be ambiguous. That's an opinion. What one person considers bad in given context may be neutral, even acceptable. Yes. Being a bad person connotes near criminality or serious misconduct, sexual misconduct. I agree. By citing to a tweet response with the tweet being responded to, has failed to show the full context. That's a fair point. Not that really matters anyway. Appellant has failed to show the court the full context. Okay. The statements in the seventh tweet contain absolutely no context to explain why Marchi was upset with whomever she was writing about. Doesn't even touch on criminality. She could have easily been distraught as a bad loss of Scrabble over having her hair yanked down. Okay, we'll skip that one. Neither did the brief show how any statement in the February 8th tweet is defamatory, though Appellee Marchi does state her recollection that Appellee whispered something sexual to her, statement of fact. She never accuses appellant of serious misconduct and not even imply the same. Predator kind of does. Appellant has not also stated where in the tweet Appellee Marchi falsely accuses him of crime, recognized under law, nor does she, because she doesn't. Indeed, appellant testified that if he does know a crime, appellant doesn't even know if any crime qualifies as a predator. None do. That is off point. That's off point. It's also an allegation of serious sexual misconduct. And also, like, predator as such is not a crime anywhere, right? Of course, there's no Texas, there's no Texas crime, nor that would classify you as a predator. And now that's probably not a term that is used by a court anywhere. But yeah, we all know what we're talking about, right? So that is off point. No, but nice try, but no, I don't buy that one. No, you don't even know if any crime results in classification of predator. None do. No, not buying that one. Appellant is unable to explain to the court, just as unable to explain to the trial court how it's defamatory under Texas law, which is why he's not even attempted to do so. Okay. Is sexual predator a legally defined crime? Probably not. But, just because it's not a legally defined crime doesn't mean you're not accusing someone of a crime, nor of serious sexual misconduct, right? So, no, you can't be that clever. I'm sorry. Nope. If you were convicted of rape, you'd only be called a rapist, not a predator. Lame. Sexual predator is a specific category of offender? Really? Unto itself. There's a category called sexual predator in Texas. Or anywhere in the United States, but mainly in Texas. I'm doubtful. Appellant bears the burden of proving Marchi's statement is false. The difficulty belying his inability to do so comes from the fact that statements were so subjective or they could not possibly be the truth or falsity or otherwise admitted to. Subjective nature of the statements, yeah, exactly right. We've got registered sex offenders, right? Then we got ones who committed even serious crimes, more restricted cases, sexual predator. Doesn't sexual predator refer to sexual offenses against children? As a technical designation, I've never heard of it referred to as a technical designation, as defined by any law. I've never heard it as a technical definition in the United States. California, maybe. I don't know the law everywhere, so maybe California has it as a technical definition. Okay. Well, let's check it. Let's check it out. Let's Google sexual predator California. Okay, let's see. Apparently, this one says sexual violent predator has a narrow meaning in California. Sexual violent predator is a very narrow meaning. Okay, so California Welfare Institution Code defines sexually violent predator. Okay, so apparently in California, it is a technical definition. We have all learned something. Very good. Excellent. There you go. In California, it is a technical definition. But even in California, I don't necessarily know that you, by using that term, because again, we're looking into what like the average person reading it would understand, right? It's normal meaning to an ordinary, reasonable observer, the ordinary man test. So unless you use the phrase sexually violent predator in a tweet in California, I think most people would not necessarily read the word predator as necessarily implying that particular designation. I don't know what the zeitgeist, the general understanding in California is, but I have to think in sort of that most people are not like making that particular association. They just refer to it generally in a sexual way, not that specific delineation. But interesting technical point noted. The subjective nature of the tweets make it nearly impossible to put forth evidence disparaging, but the burden to do so remains his. As the February 8th tweet, appellant surprisingly claims to specifically deny that he grabs the hair, yanked her hair back, and whispers something in his ear. Let's take a look. Miss Marchi certainly wouldn't be the first woman whose hair you've pulled. No, we've established that. I don't know exactly what that means because I don't have the predicate. So it's possible Marchi perceived pain when you pulled her hair in the lobby and you're unaware. I have no indication where it happened that was anything offensive or painful about it. And you're reading a little bit too much into it for me. Is reasonable or average the reasonable person? What are you asking me? The average reasonable observer? The ordinary man test? Is that what you're asking me? Like the average or the reasonable man test? When you're doing things objectively, you're asking the reasonable man test. The man on the bus. I forget the exact one. The man on the man on the train. Yeah, the average ordinary man of common intelligence and understanding. You know, the average person who, you know, would read it and understand it to what it means. Average ordinary observer of careful and normal intelligence. That guy. That guy. The man on the bus. The man on the train. That guy. Ask him. Though appellant asserts unnecessarily didn't have sexual interest in Marchi, his testimony is contradictory and not clear and specific as to what he said. Do you recall if he said anything into her ear? I do not recall I said anything, but I did was literally something like, "Oh, I love you here," or "I love it," you know, it's that kind of thing. Sounds like that. So is that long phrase is considered objective? Yeah, basically. That's one way of looking at what objective is. The ordinary reasonable observer is objective versus subjective is you. Yeah, so that's one way of what objective would be. Yeah, ordinary reasonable careful observer, ordinary prudent intelligence. Appellant's testimony that he did not say anything to Marchi while controlling her only doesn't recall saying though. So, well, you're asking about something that occurred quite a few years ago, so you know, you wouldn't expect him to flat out deny it. His testimony is not that he didn't say anything. He simply conveniently assumes that if he did say, it must have been innocuous. But if clear means ambiguous, sure, and specific means expleting, the evidence anything but clear and specific. Yeah, I think that's a fair point. As to the statement whispered, as to what happened to you, that is a bit hard to get to the defamation. You know, as to what specifically happened to you, it's a bit difficult because the line between what he says and the line between what you say is pretty close. You know, so it's a little bit hard to say that you're blatantly lying or, making a false statement. So it could be an issue of perception. I still think you're on the hook for the predator tweet. I still think you're on the hook for the I've heard from about 10 other women thing. Those statements are fact. Of course, we got to get into public figure stats and all kinds of stuff on top of that. But the stuff you're relaying as to happen to you, probably the stuff that happened to other people is a little bit more nebulous. Appellant alleges Marchi continued that he had done this exact thing to Haftover when I personally know. Marchi only stated she had heard that he had done so, not that he actually had. I don't, and still that's a statement of fact. I had heard it. Did you hear it? I mean, it's a statement of fact unto itself, and I think republication looks pretty good. Appellant not sought any evidence in the record to establish he did not hear it, and therefore it's not met as burden of proof. That's fair. A public figure must prove actual malice. Appellant was therefore required, especially no error, that he is a public figure, to show they remain with reckless disregard. In other words, they need to entertain serious doubts about the truth, high degree of awareness of probable falsity. You knew or should have known is basically a better way to put it. Instead, appellant cites no evidence and has none regarding Marchi's state of mind. It's not really quite state of mind. It's knowledge or lack of or recklessness, disregard. Not quite state of mind. Yeah, well, there's three appellant briefs or appellee briefs. So this is our last one of Vic for a while. Thank God. This is our last one of Vic for a while. But there are 3 appellee briefs. So now we're going to do all 3 of them. So now after this, Isaac, we have done the original complaint, the original response, the TCPA, the response, the TCPA hearing, the appellant's brief, the appellee's brief, the appellee's brief, and the appellee's brief. We're becoming pretty knowledgeable about the Vic Mignogna situation. Yeah. Appellant boldly claims that this brief is contradictory. Vague denials of clear and specific. Appellant testified otherwise. Do you have any evidence that you're aware of Marchi and actually believe these statements to be true? At the time she wrote them, at the time she happened, at the time they wrote them. I can't answer for her. I don't know what's in her mind. I can't say whether she believes they're true or whether she's joined the appellant. I don't know. Appellant was required to show Marchi acted with malice, but he did not do so. He failed to cite any statements that accused him of crime or engaged in misconduct beyond generic reference. More importantly, the case law does not support the vagueness. The only statement in the record that actually contains a statement of fact is when the outcries of truth about what they did. A statement conspicuously making for the filing. Equally conspicuous, appellant admitted to the truth in the deposition. I still think the other one is looking a little bit better. Sounds like I'm not giving this guy enough of a chance. Really? I hope you're being sarcastic. I really hope you are, because man, geez. If reading 10 different legal filings isn't giving this guy enough of a chance, I don't know what more they want from me, man. What more do you want from me? Just to tell you everything you want to hear, right? Ma'am. Yeah, thank you, Isaac. Jesus. Yeah, I do love the Vic people. Even in the last video, they're like, you don't know what you're talking about. Your ignorance of the case is so bad. I'm like, guys, I mean, I've read like 500 pages of documents at this point. I have a pretty good hold on it. I won't claim I know as much as some of you guys in Vic world because you guys know everything cold. But I've got a pretty good handle on it. So, jeez. And, I also want them to understand that just because I'm saying Vic will lose doesn't mean that I think he should lose, right? I'm giving a legal opinion as to what I think the legal posture is here, right? I don't know what actually happened to Vic. I don't know if he's been falsely accused. I don't know if he didn't do anything. I don't know if they're making up. I don't know anything. I don't even know, because I haven't certainly not read the Second Amendment and all of its filings because it's so long. Maybe we'll put that on stream. Maybe that'll shut the Vic people up. If I read the entire Second Amendment and all of its attachments, we'll go on for 400 pages and read that. Maybe that'll get them to shut up. But, it's like, I'm not saying like what should happen. I'm just like giving a legal opinion as to what will happen. It's like, okay, my legal opinion is still Vic poached the case, or more properly, his attorney poached the case, and I think Vic is going to lose. So, that's what I think. Not saying it's good or bad, just it is what it is. The damages were caused by Marchi is ludicrous. In addition to failure to cause, set up cognizable claim, burden of both circumstances proves general damages for the per quad. Appellant confirmed Marchi's name was never mentioned by Funimation was conducting investigation. Also testified deposition, Marchi's statements could not have been impacted. Not specifically cited any conventions canceled after the statements as depositions. Appellant was even on track for his typical number of convention appearances, having already had 9 at that time, professing attendance at 20 to 30 in a year. I thought it was a little bit higher than that. Rather than provide specific evidence of damages, appellants only establishes absence. Appellant's lack of explanation amounts to waiver. Okay. Yeah, it's gonna be too tired that Reddit should get through. Yeah, they will never be satisfied until I agree that they're right. Right? And not like if I thought they were right, I'd say so. I mean, I agree with Vic when I think he's right, agree with them when I think they're right. So it's like, I don't know. The fanboys are fun. No, the judge has absolutely no idea what he's doing and has made all these many mistakes and can't see anything and blah blah blah. And I'm like, really? I suppose that's possible, but I did read the TCPA hearing and I didn't get that impression from the hearing. It seemed like the judge was reasonably with it. Oh, and I did like that in one stream. That was a little bit of a funny moment to me personally on stream. In one of these things, I forget which one of them because I've done so many of them now, but in one of these things, I was talking about this thing, and someone in the stream commented, like, you wouldn't feel that way if you had read the TCPA hearing, right? That was the comment, essentially perfect. And so I said, well, I did read it. In fact, I live streamed, reacted to it. Blah, 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 blah. And this is what I think. And then someone said, yeah, but you weren't there in person. You're right. I wasn't there in person. You got me. The trial court's dismissal for tortious interference with existing contract is not reversible. Appellant sorely failed to meet the burden to proffer clear and specific that a valid contract, they willfully interfere, inference causes damage. Yeah, if you're trying to pin everything on this one tweet, like even the Predator thing, it's a little tough. That was on Viva Stream. It was on Viva Stream. You're right. That was on Viva Stream. It wasn't even a stream on my channel. I've talked about this on other channels. It was on Viva Stream where I got criticized by that people too. You're right. It was on Viva Stream. Well spotted. Yes. You're right. I remember now. Yes, I remember now. You're right. Just in the trial court, Marchi struggled to respond to the allegations because it scarcely can be said to exist in the first place. Yeah, and then people leaving comments on Viva's channel about how I'm an idiot and like all this kind of stuff, man. It's like, Jesus Christ. Marchi cannot help but point out that the court, and the really, really funny thing to me is like in the event that like Vic wins, they're gonna like shove it in my face. I'm like, I did only give him I only did give Funimation like an 85% chance of winning. I didn't think it was a slam dunk. So like, even if it like gets, I'm not saying I can't be surprised and won't admit that I'm surprised if I'm surprised, but like, if this somehow goes the other way, I can see reasons that would go the other way that wouldn't particularly surprise me. I can see a whole bunch of reasons that would surprise the hell out of me. So, just because I look for, in the event that this gets reversed, they're going to say, ooh, told you so, one civil law, told you so. But in the event that the appeal court upholds it, I don't see a lot of them coming forward and saying, you know what, uncivil right, you were right the whole time. I couldn't believe I couldn't see it before. But the appellate court, man, they agreed with you, man. You were right. Don't see that happening particularly. Appellant alleges that Marchi knew that appellant attended the conventions, attended some with him. Doesn't seem to identify which elements. Appellant vaguely argues that conventions canceled appearance and breach of contracts. They were a little vague in the original pleadings, yes. Could it be dismissed without prejudice or is not applicable? What do you mean, this case? It has been dismissed with prejudice. It was dismissed with prejudice. And Vic lost. So he's appealing. Could the appeal be dismissed without prejudice? I'm not sure how that would work. I suppose it's possible the appeal court could say that we're going to dismiss without prejudice to allow him to start over, but I do not see that happening. That would be really bizarre to because the trial court has already said it's with prejudice, and so for the appeal court to say no, we're going to allow this to happen without prejudice. No. Yeah, civil is wrong, just getting ahead of the game. Yeah, pretty much. Continuing the static of the screen in lieu of a clear picture. Interesting metaphor. Appellant proudly states he suffered actual damages. Yeah, his original pleadings were thin. Knowing the burden was to put forward, one must seriously wonder why it's asserted as a point of error. Despite the error to plead clave, offers nothing in the record. Yeah, the brief from Vic was not super impressive. Appellant fails to show while the record contains clear and specific evidence, reasonable probability it would have entered a relationship. Marchi interfered. Marchi's conduct with Tortious interfered approximately and suffered loss. Marchi does not dispute his appellant previously and regularly appealed at several conventions. What appellant doesn't want to own up to is that he's rarely invited to the same convention consecutively, as attendance at conventions fluctuate year after year. And someone was saying in a prior comment, I don't know if this is true, but some of these conventions have a general policy to not let the same person appear year after year, which I guess makes sense. Hello, Leonard. How are you doing? Thank you for joining the never-ending Vic Mignogna case. Would you like to tell me how I am completely legally ignorant and I don't know the first thing about the Vic Mignogna case and how I've gotten it completely wrong and I'm a total failure at everything I try? Because you too can pile if I know you're looking for ways to continue to grow your channel and stuff. So all you have to do is come out and publicly say that uncivil law is completely full of it and Vic Mignogna is a god among men and the judge is an idiot and surely justice will be done. It's all for you, baby. It's all for you. I don't know much besides Vic's lawyer did a shit job. Shh. That's not how you get the ratings. You have to say the opposite of that. What you meant to say, let me help you out later. What you meant to say was that Vic's lawyer did an amazing, legendary job, and it was that Judge Chupp, that biased judge who can't see the forest of the trees and has it out for the entire anime community, is here to destroy us all. Ty Beard is a god. That's what you meant to say, I'm sure. Vic has a lawyer. It's Ty Beard. Vic's lawyer is Ty Beard. That's his guy's name. Vic has a lawyer. Yeah. What appellant doesn't want to open up to is unless you meant that really insultingly. Unless you meant that really insultingly. He doesn't even have a lawyer, because not even Ty Beard is really a lawyer, unless you meant that as a real insult, which, okay. What appellant doesn't want to is rarely invited. He fails to establish that Marchi ever interfered with the business relationship. They did so tortiously, proximately caused damage, or was damaged at all. In fact, testified didn't know of a similar convention Marchi reached out to. That would be a problem for tortious interference. Yes. If you don't know that they reached out to a single thing, a little harder to tortiously interfere. Yeah. By lumping unappellees together, appellant has necessarily defeated any argument. Appellee relies heavily on limited Texas jurisprudence that TCPA, a court may draw reasonable inferences from circumstantial evidence. Yes, they can. For the supposition that because appellant thinks he cobbled together documents he interprets a certain way, the trial court should do the same. However, just because a court could draw it doesn't mean they should. Fair. Inferences drawn from circumstances must indeed be reasonable. When inferences from circumstances are speculative and conclusory, just as the inferences relied on the hope of claiming simply too great for an analytical graph for the court to traverse. That's a nice little burn there. That's a nice little burn there. Yeah. Yeah. As previously stated, knowing appellant's burden was to put forth clear and specific evidence establishing the prima facie case, one must simply wonder why this is an error at all. Issue 4 doesn't deal with Marchi. Issue 5, the claim for civil conspiracy is not reversible. Yes, because the underlying thing is just not there. Yeah. Boiled down, appellant's claim seems to be appellees did not establish their conduct was promoting, pursuing, or defending. If the legislature had intended to limit the application of civil conspiracy, it would have done so. I don't quite buy that, but the more to the point is that you can't have a conspiracy without an underlying tort. You can't have just like a general conspiracy. That doesn't make sense. Appellant did not appeal the trial court's order of the applicability of TCPA, only dismissal. As such, appellant limited his argument to putting forth clear specific evidence, which he did not do. He ignores both the trial court and in this brief that his burden to prove forth that as a member of a combination of two or more persons, the object of the combination was to accomplish an unlawful purpose or a lawful purpose by unlawful means. Members have meeting of the minds. One of the members committed unlawful overt act and suffered injury. Yes, that is your basic conspiracy law 101. Nothing in the record even hints at these elements. It is a little bit problematic, yes. Filing for a civil conspiracy in Texas relies on commission of another wrong. Yes, you can't. You can't really just have a conspiracy in the abstract. You know, we have an agreement to do what? Things. Yeah. The trial court properly refused to consider appellant's untimely Second Amendment petition. This for me is the money issue. This for me is the money issue. If they can prove the trial court properly refused to consider the Second Amendment, it is game over. Funimation couldn't do it. Monica and Toy couldn't do it. Can Marchi do it? Can Marchi show the trial court properly refused to consider the Second Amendment? Because if she can, it's game over. So let's figure out if they can do it. Let's find out. Good times. Appellant argues the trial court has no discretion to disregard the untimely petition, particularly given the 100 new alleged pages. Neither the record in this case nor the civil procedure report supports the conclusion, because the best place to start is often at the beginning. Rule 1 offers guidance. The proper objective of the rules of civil procedure is to obtain a just, fair, equitable, and impartial adjudication of the right of litigants under established principles of law. Texas Civil Procedure, Rule number 1. Good. Appellant's burden in this point of error then is to show why the refusal to consider the tardy Second Amendment present a just, fair, equitable, and impartial adjudication. He cannot do so. He filed his original petition on April 18th, and the record is clear that being investigated his baseless claims well beforehand. Nice burn. After Marchi filed her TCPA on July the 19th, appellant had a month and a half before his response was due. Indeed, the parties set forth and agreed upon scheduled clarifying deadlines and confirmed agreements. August the 30th, appellant's response and objections. September the 3rd, appellee's replies and objections. September 6th, hearing on the motion. This schedule was agreed to by the parties and filed with the court. The schedule thereafter was binding on the party without recourse. Okay, it's a contract. It's a contract. All right, it's just a contract, guys. It's an agreement between two parties, both of which are supplying consideration. It's a contract. It's a contract, right? So like all contracts, it's binding. We can call it a Rule 11 agreement. It's a contract. Okay, it's a contract. Two parties, consideration, it's a contract. Great. After appellants failed to timely file due to a technical failure, the trial court deemed it timely filed. Okay, yes, because, you were late by 15 minutes. We'll give you a break. Fine. 3 days later, though, on the same day, appellee's reply to the appellant's response was due. Appellant, without warning explanation, filed a second amendment containing hundreds of pages of documents that are not attached to his original response and reattaching the remainder of the alleged evidence that was attached in the response. Hardly an action that can be deemed just or equitable. Well, so far, Marchi's doing a much better job of arguing this point than either Funimation or Monica or Toy did. So far, they're doing much better. There's 4 parties, I guess. There's Vic, there's Funimation. Monica and Toy are kind of treated as one party for some reason. They're not married, but they're engaged, but they seem to be treated as one party effectively for some reason. So we've got Vic, we've got Funimation, we've got Monica and Toy, and we've got Marchi. So we've got 4 parties, kind of, or 5, depending on how you're counting. Citing a learned treatise on the subject, the trial court ruled the amended after the TCPA motion is filled would be contrary to the purpose of the statute and possibly a violation of the rules. Said treatise references a case out of Dallas Court of Appeals holding a motion to dismiss under the Texas Medical Liability Act could not be subverted by filing an amended petition, and California case finding a trial court there properly denied a request to file a proposed amendment while the anti-SLAPP motion was pending. This court has also ruled that an amended petition filed after defense filing a motion to dismiss our Texas Medical Liability Act was wrongfully considered by a trial court and remanded for an error dismissing. Support for a trial court's determination also exists in other rules of procedure and cases. The Texas Supreme Court expressly requires a trial court to rule on a 91A motion to dismiss without regard to a late filed amended petition. In summary judgment context, the summary judgment proceeding is a trial within the meaning of the rules. Of course it is. Rule 63, of course, dictates... Oh... Interesting. I like this argument. Oh, okay. I have to give this a second thought. I have to give this a second thought because I see what she's about to do. I see what she's about to do, and I have to give this a second thought. Here's what she's about to try to do. One of the rules deals with filing before the trial, right? One of the rules that they've been quoting at me endlessly deals with like when you can file stuff and how long it has to be done before the trial, right? So one of the things I've seen from the Vic people, the Vic supporter people, is that the TCPA hearing is not a trial, so the rule doesn't apply. That has been their argument. I've seen that argument many, many times, and I already know where this is going. I've seen into the future. They're about to argue that the TCPA hearing was a trial for the purposes of the rule. They're going to argue that it's equivalent to a summary judgment proceeding, so they're going to argue the TCPA hearing is actually a trial, and therefore the rule that deals with when things can be submitted for a trial binds this proceeding. I don't know if this argument's going to work or not, but I love it. I love the try. Let's find out. The Texas Supreme Court expressly requires a trial court to rule on a 91A motion dismissed without regard to a late filed amended petition. In a summary judgment context, a summary judgment proceeding is a trial within the meaning of the rule. I know where we're going now. Rule 63, of course, dictates a filing within 7 days of trial may be only filed after obtaining leave of court, which appellant did not do. Appellee Marchi, together with other appellants, objected to the amended petition, showing that based on case history, the Rule 11 agreement, proximity hearing, and filing the same day, appellant's second amendment functioned as surprise. The trial court had discretion to agree and disregard to which it did. You were a little bit thin on the connection of saying the TCPA is a summary judgment, right? Summary judgment is a trial, but is the TCPA the summary judgment? I don't think this argument works. It's a really clever try, but I don't think this argument works. Because I don't think the TCPA hearing is a summary judgment. Because it's effectively a motion to dismiss. The TCPA functions as a motion to dismiss, not a motion for summary judgment. And the reason it doesn't function as a motion for summary judgment is because you don't have the kind of evidence you would at summary judgment, which is to namely say like the depositions and stuff that, were frozen in place because of the TCPA. So I don't think you can view the TCPA hearing as the equivalent of a summary judgment to view it as the equivalent of a trial to get this rule in. It's a really nice try. It's very clever, but I don't think it quite works. But I admire the effort. That's top-notch lawyering. The trial court properly disregarded the new allegations. Appellant ultimately filed. Even if it had considered such evidence, though, the effort offered was nearly based on personal knowledge, factual evidence, or anything other than hearsay speculation. So this is the best reciting of the rule and why it does or does not apply to the situation. And they're arguing that the trial court did indeed exclude it. Paragraph 85. At this point, I wish I had a copy of the clerk's record so I could see volume 6, page 3225 to see what the court actually said. Because whether or not it was actually dismissed by the court, I know has been a point of contention. But they're just treating it like a fait accompli. They're treating it like it did happen. Which, unless the other side really responds back to, I think this issue right here is the issue the appeal court of appeals is going to latch onto, because it's the easiest issue. It's the easiest issue to dispose of the case. Courts are lazy too, so they're going to find the easiest issue to dispose of the case, and this is the easiest issue, that the second amended isn't in there and everything else was defective, and the trial court had the discretion to exclude it, and they did. So unless the other side comes back with a reply brief and really shows that it's still, that the trial court didn't actually exclude it, or it was left open or something, unless the reply brief really deals with this, I think this is going to be the basis. I think this is going to be the basis of the appeal court's action right here. I think this is, is that the trial court had the ability to exclude it as a surprise. It's within their discretion. In the absence of a rule to the contrary, courts have quite a lot of power in trial management. They gave you a deadline. You tried to circumvent it. The trial court smacked you down hard. You're done. So unless I think Ty Beard's best argument in reply to all this is to argue that the trial court never actually ruled on that issue. They never actually ruled on it, which I don't know how much that really helps you, because then the Court of Appeals would remand it. The trial court would say, okay, I'm going to make sure that's in the record now. And then you go back to appeal and you just lose anyway. But I think that's your best move to forestall, is to say the trial court never really ruled on it, and so it was never clear. And so therefore the trial court, it should be at least remanded to clarify. So I think that is Ty's best reply in his reply brief, is dealing with this. Otherwise, this right here is my prediction for the basis for the Court of Appeals decision. This is it. This is the foundational issue. The second amended isn't part of the record. It was filed after an agreement by the parties. It was within the trial management procedure. The trial properly excluded as unfair surprise. It's not on the record. Nothing in there counts. And because it's not the operative petition, and we go back to the first amended, it doesn't have anything like there. Therefore, you don't have substantial evidence. Therefore, Vic loses. All right? That's the opinion from the Court of Appeals. And I'm writing the decision from the Court of Appeals. That's how I'd write this decision from the Court of Appeals. Easy, by the numbers. Just done. So if Ty wants to try to get outside that argument, he has to come back very clearly with saying, look, it was only taken under advisement by the court. They never said they didn't consider it. We think it is the operative, it was unclear on the record, that whatever. And they should go back and we should do it. And once you do, of course, it's not an unfair surprise because they've had all this time to think about it. So therefore, we should reopen things. I think that's how Ty I think Ty's best attempt to try to beat all this. I don't know that any of that's going to work, but I think it's the best effort to try to fix this mess. If a court agrees with the Rule 63 argument, doesn't set up future precedent for hearings. Anything the appellate court says sets a precedent for future TCPA hearings. Anything the appellate court says sets a precedent, unless they say it's non-precedential, which I guess they can do. But yeah, anything the Court of Appeals says is precedential. So yes, anything they say will become binding on future TCPA hearings. Lemon Party says, in file ruling, Chubb said all further prayer for relief is denied, which denies the motion to strike it from the record. Maybe. And that's Ty's best argument. That's Ty's best argument, by the way I see it. That's Ty's best argument, is to say that it is on the record, it was never stricken, it was unclear, some version of something like that, it was never conclusively ruled on, or it was ruled on and it's brought in, and so it wasn't excluded. But that is Ty's best argument, is the second amended. So I just spend all my time on the reply brief dealing with that, because that's the only issue that really matters. Because if Ty loses there, you're just done. Yeah, so you might well be right. You might well be right, Lemon Party, but it's up to Ty to make that argument. And I don't think it was made on his original brief. So on his reply brief, maybe he'll make that argument better. One can only hope, because otherwise I can write the Court of Appeals opinion in my head. The trial court properly disregarded the new alleged declarations. And, this is another point where I don't think that the Vic people fully comprehend the whole realities of it. They think that I am ignorant of the record. You think the Court of Appeals is going to be more aware of the record than me? I don't think so. I don't think so, Tim. The Court of Appeals is really, really, really busy. I have done probably more reading on this than the Court of Appeals will wind up doing. Just facts, guys. They're probably not. They're not going to read 6,000 pages of transcripts and hearings. It's not happening. They're not happening. They are going to look for the easiest things to do to get it off their docket for the next thing. All right. So odds are better that I've done more research and more on this than the Court of Appeals will, in reality. So if you think that I am ignorant because if only you read more, if only you knew more, if only you learned it deeper, you'd see the truth. Guys, I'm just telling you. The Court of Appeals isn't going to do all that. They're not going to do all that. It's just not happening. Okay? If it is not clear to them, they're just not going to go digging. The trial court will dig for you. That's one of the things the trial court does. The trial court will dig. But the appeals court won't. No. Especially on this standard of review, abuse of discretion, clear error, not happening. I've done more research than the Court of Appeals will wind up doing on this. And I can write the Court of Appeals decision in my head right now. So Ty has to come back and show me why that's not the right decision. Hasn't happened yet, man. Sorry your ADD is driving you nuts. Appellant conflates all appellee's point of error in 7 on his brief regarding the satisfaction. Does not make any reference to Marchi nor citation. Therefore, waive the complaint with regard to Marchi. Did object to appellee Funimation Toys evidence. Did not object to any Marchi's evidence. Okay. Then we get to the award of attorney's fees. And in conclusion, considering appellant's lack of substantive briefing and vacuous record before this court, the trial court reached the correct outcome: dismissal. Only by citing clear and specific evidence could appellant have avoided this outcome, but unable to do so and remains unable to do so here. Not only does the record establish that Marchi neither made actual statements nor engaged in it, interfered with business dealings, shows appellant merely seeks to place blame on others for self-imposed misfortune, an outcome not permitted by Texas law. Taking the truth together, protections by TCPA, the trial court properly dismissed the claims. Regarding appellant's consistent misdirection regarding for the rules of civil procedure, the Rule 11 agreement, the late filings and tardy submission was improper and cannot be allowed to set precedent for future litigations. On the contrary, the rules require order, just, fairness, and equity, lest litigations and aggressor being too much freedom to abuse the legal system after they abuse those in their lives. That's a little bit too much. I don't really like that last line. It's a little bit too much. And therefore, we want stuff. And we're signing this and certificate of service. Okay, great. So that's it. We're done. Very, very exciting. Very, very exciting. So that is the end of the appellee's briefs. So we have read all 3 of the appellee's briefs, the appellant brief, and the TCPA hearing, and the 4 underlying things, and all that good stuff. So, So I suppose next is Ty's reply brief, and possibly also a motion to strike for being in violation of the word count. Sure. And then at some point in the future, I guess we'll schedule an oral argument, which I will go to, because that will be entertaining. Fort Worth is only about 2 hours drive, so why not? We'll go up there and check it out. So if you enjoyed this stream, or if not, or if you hate me, or if you think I'm an idiot, please like the stream. It helps us grow. We really appreciate it. And that's the end of our Vic Mignogna coverage for now. So until later, my friends, I hope you're well. Cheers and goodbye.